Welcome to episode number 25 of the Crisis Intelligence Podcast. Today is Sunday, November 23rd, 2014. I'm Melissa Agnes, and this podcast is brought to you by Agnes Day. Let's talk crisis intelligence. Hi, Maanit. Welcome to the show. Why don't you introduce yourself and tell us about what you do?
All right. Well, my name is Maanit Zemel. I'm a lawyer. I practice out of Toronto. I have a background in commercial litigation and internet law, and that's what I do full time. I practice litigation, of course, for my clients, as well as I advise my clients on various matters relating to the internet, including Canada's anti-spam legislation, cyber libel, cyberbullying, privacy, etc. I also, in addition to my practice, I also teach business law at Ryerson University in Toronto.
Awesome. And we are here to talk about Canada's anti-spam legislation because it's new. And it applies to, I want to say this up front and center for everybody who's listening, it applies to every organization, no matter where you are in the world. And it's serious.
Yes, absolutely. That's exactly it. It's any organization, any business, any individual, anyone who communicates electronically with someone in Canada would be subject to Canada's anti-spam legislation, or as we like to call it, CASL.
CASL.
Yeah.
So CASL. And, it's funny because, well, it's not funny. It's actually quite annoying. So I receive, when I'm home, I'm in Canada. When I'm not traveling for work, I'm in Montreal. And I think this week or last week, I sent 2 emails to organizations which I know, so I sent them, just saying, hey, I didn't opt into this, and there's no unsubscribe button here. You're sending to Canada, crisis prevention. Here's what you need to know, and do it before somebody else who isn't me reports you.
Yeah, absolutely. And you are nice enough to tell them, as opposed to going to the website where anyone can go and file a complaint. And, some people will just go to the website and complain. And next thing you know, you're faced with a regulatory situation. So, yeah, no, it was nice of you to send them that email and give them a heads up.
Well, I don't like to put people in crises, but that's not to say that both of these 2 organizations in these 2 cases, I knew them and I respect them. They just don't know about it. And that's the other thing is that it's brand new. This legislation is brand new. However, I can say that I did send an email or a newsletter that I did subscribe to a while back. I don't want to be a part of anymore, so I tried to opt out. Couldn't opt out, so I sent them an email saying, please unsubscribe me. 3 more times they sent me the email, and I did report them.
Oh, good for you then. Well, in that case, I think it would be quite appropriate to report, not only because they didn't unsubscribe you, but they are obviously ignoring your request, which were, again, done in a very nice manner. And the law here in Canada is not only that it requires someone to remove you from the list when you unsubscribe, but it actually requires that organization or business that is sending you those emails to request your consent before they even send that first email. So in addition to having an unsubscribe, they should have asked for your consent in the first place. So either way, they would have been in violation of the Act.
Yeah, well, actually, in one case, I had subscribed. I just wanted to unsubscribe, which is fine.
Yeah.
And I love that. So I want to dive into, start at the beginning, but we will talk about the opt-out versus opt-in, which in the States is very frustrating. They have you are allowed to opt out rather than you are required to have to opt in the first place, in which case they already have all of your data and information.
Yeah, that's exactly it. And I think, it depends how you look at it. If you are from the receiving end of those emails or those text messages. So the U.S. Anti-spam laws are certainly not as stringent as Canada. They allow anyone to send you those emails as long as you don't say anything. If you're silent and you don't say I want out, don't send these anymore, opt out, then they can continue sending you those pesky, annoying marketing or other type of emails. On the other hand, if you are the organization or the business that's sending out those emails, certainly the U.S. laws are allow you to do that and allow you to continue your online marketing campaigns as long as people don't opt out. On the other hand, in Canada, it's not that case. In Canada, as you just mentioned, it's an opt-in regime, which means that unless someone opts in to getting those emails, you, the organization, shouldn't be sending it in the first place.
So let's talk about, let's set the stage. So CASL came into effect very, very recently.
Yeah, July 1st, 2014. Yeah.
And before that, was it because in Canada, were there complaints with was our regime just not adequate enough, or how did the CASL law?
Well, actually, it goes back quite a few years. We in Canada were one of the last developed countries to pass anti-spam laws. Before July 1st, 2014, we had no anti-spam laws, and we were colloquially sometimes referred to as a haven for spammers and hackers. Of course, the government wasn't happy with that perception, and was getting a lot over the years, and this is going back probably to the somewhere around 2005, 2006, was getting a lot of pressure from its G20 partners to do something about this. And so, as it takes time passes, and the government tried to pass something, and finally did in 2010. So CASL has actually been a law since 2010. Where it was passed by Parliament, and that means it applies all over Canada. And what they said is, well, here's the law. It's very strict. What we're going to do is because we were considered the haven for spammers, we are going to now be considered the opposite of the haven. We are going to show the world that we can be tough on spammers and we can be tough on hackers. And so they passed this law, which is probably one of the harshest anti-spam laws in the world. And after they passed it, they said, well, okay, now that we've passed this law, let's put it up to the community, to the business community, the various organizations out there that are involved in emailing and sending out electronic communications, and get their feedback to see how we can actually make this work. And there was consultations with pretty much every industry in Canada about how to make this work, and everybody was lobbying the government for exemptions, because really it's a very tough law to follow. And there were just lots of pressure from everyone, and eventually they came up with what they came up with, which is pretty much this, and we'll talk about it, of course, and what this law says, but giving very few exemptions to very few organizations. Very few type of emails are actually exempted from the requirements, and that took 4 years to come to, and eventually the law came into force on July 1st. So it's been long in the making, but it's here.
So let's talk about. I have so many questions.
Yeah,
and I think it's so interesting, and I think that anti-spam, or just protecting people from spam, is just so valuable for the individual.
Oh yeah, for sure.
For sure.
I mean, if you look at your email on a daily basis, I have to say I don't know if you've noticed a change since July 1st, but I certainly have. Before July 1st, I used to, as I followed this law, I used to look at my emails and see, this is my work email. I'd say probably 60 to 70% of my daily emails were non-substantive emails. All right, they were something. I've
got some really great spam filters, but I can tell you that even like most people go into their spam. So people will say, "Oh, send me an email saying, oh, you sent me this, and I didn't see it. It was in my spam." And I always think, wow, you check your spam folder. If I open up my spam folder, I get about, I would say, between 3,000 and 5,000 spam emails a month. There is no way that I'm going to filter that. So if your email gets lost in my spam folder, like, it's gone.
Yeah, that's certainly what that's, absolutely. That's one of the problems that come with spam. That being said, when this law came into force back in 2010, and well, they started talking about this in 2008. The spam filters weren't that good. Like right now, we have really good spam filters. Whether you use the main providers, whether it's Gmail or Outlook, they've got some really good spam filters. Back in 2008, we didn't. So I always say that this law that came into force in 2014 is really meant to deal with a problem from 2008. That being said, there are still, as I said, I found at least 60% of my emails not to be necessarily spam as we understand spam to be. And they're not trying to sell me a particular, performance enhancing drug, or it's not an email. They're not emails from a prince somewhere in Africa asking me for money. But they're still what I would consider non-substantive, because they are trying to sell me something, even if it's something legitimate, right? And there is some it's annoying, I have to say. Everybody's annoyed by that, but also it's frustrating because you do tend to lose. There is a potential of losing important emails in that sort of sea of spam. So, and whether or not it goes to your spam folder or not, right? So I get that. And that's why it was an important law to pass. There's no question that we needed this law.
I think the world needs the law.
Yeah, well, everybody does, right? And it's very important to have. That being said, the question is how this law, what this law does and what it says is a whole different issue. And one of the things that makes CASL, Canada's anti-spam legislation, relatively unique in the world is that it doesn't actually apply to spam, or what we would consider spam, me and you. It applies to any email whatsoever. So it applies to what the legislation calls commercial electronic messages, and those are very broadly defined in the legislation. So that is why it becomes a little tricky. It's not as simple as, oh, this is spam, I can't send it. No, is this a commercial? Yeah, exactly. Is this a commercial electronic message? And commercial electronic messages in the Act are basically, when you boil it down, are any electronic messages. So it could be emails, it could be text, it could be in messages sent through social media like LinkedIn or Twitter or Facebook. And those are messages that are sent in the course or that are intended to encourage participation in commercial activity. Well, what's commercial activity, right? It's so broad. And in the legislation, it's very broadly defined to pretty much mean anything that you do in the course of commercial conduct, whether or not it's for profit. So that's also something that is important because it is fairly it's established and it's common knowledge that commercial electronic messages, as they're defined, are emails that are also sent by nonprofit organizations and charities. And we're talking about fundraising emails. Those will be covered by the Act. So this is the kind of scope the Act applies to. And just from that, you can think, well, you think of a spam email, it's usually a mass email, right? It's usually one to send out. No, commercial electronic messages can be one email sent by you to someone who you have a relationship, a business relationship, or you don't have a business relationship with, and where you are encouraging your services, encouraging them to, or promoting your services, encouraging them to consider your services or your business. And so it could be pretty much anything sent within your while you're conducting business.
So basically, that's crazy. So no email pitches. No. So many people, and it is considered spam, or I consider it spam. But when you get those, hi Melissa, I noticed that you're Agnes Day, blah blah blah. Would you consider blah blah blah? That I could consider that spam and report them.
Yeah, that is a commercial electronic message, but it could also be, it could be something that that is more innocuous than that, right? It's hi Melissa, we met at so and so, or I've been given your, I understand you're in the same business I am. You may be interested in this, right? That's a commercial electronic message. I mean, it could be anything.
So isn't that too broad? I mean, how would somebody with good intentions, somebody, for example, and I think it's interesting that you brought up LinkedIn, because I get about, a dozen LinkedIn connection requests per day, and it drives me crazy because most of the people, and I'd say 99% of people, whether legit or not legit, they just send me that generic, hi, I'd like to add you to my LinkedIn thing. And I always follow up with, well, can you tell me a little bit more? Like why, who are you? What do you do? Why are you interested? Why did you find, or how did you find me type thing? And so and some of them have really great intentions. I mean, I've met some really, really fascinating, really great people that I want to connect with on LinkedIn who didn't necessarily take the approach of, hi, I found you this way and this is why I think we should connect and I'd love to have a conversation with you. But even if they had, somebody could report them for violating CASL.
If it doesn't meet any one of the particular exemptions that are listed in CASL, and those are very specific.
Okay, so let's talk about that.
Yeah. Okay. Well, there's a few exemptions. The first and foremost, of course, we got to talk before actually the exemptions. I think it's important to understand what the Act actually says in terms of the requirements. And what the Act says, as I mentioned earlier, is that you can't actually send that email. That one email cannot be sent. You can't click send, and unless you already have consent from that person to that particular type of email. And if you don't have that consent, if you don't have that opt-in, you can't send the email. Now, that's one of the requirements. There are other specific requirements about there's a few specific things that must be in each and every email, but that's the main issue. Now, that's what we call express consent. There is the Act gives you it's not necessarily an exemption, but what it says is in certain circumstances, you may have implied consent already existing to send that particular email. And those are based on the form of relationship that exists between you and the receiver of that email. So for example, there is what is called an existing business relationship. So the Act says that if you have had some form of exchange, some transaction with that person in the 2 years before sending that email, you have implied consent to communicate with them. And so if you sold them something, if you gave them a service and they paid you for it, if you entered into a contract with them, but that's only good for 2 years, and that's something that you got to keep in mind, and that's why it's important to keep track of your customers if you are going to continue engaging with them. There's also what is called an existing non-business relationship, and that applies mostly to organizations like nonprofits. They will have an existing implied consent from their members, since a lot of nonprofits have members, and that also lasts only for 2 years. And similarly, if you're a charity, you would have 2 years to send emails to anyone who donated to you in the past 2 years. So those are the type of. It's not necessarily an exemption, but there are certain a way in which an organization, a business, can still reach out to certain individuals, right? And it's an important aspect of CASL.
So let me ask a question, because I think that maybe this has people worried. So if you have good intentions, you have never had a transaction of any form, whether it's monetary or communication, with an individual or a business, you are a business, you are not a nonprofit, and you want to reach out to somebody in particular in Canada because you think it'll be interesting, you think that there could be collaboration opportunities, you think something legit, something really interesting for both parties.
Yeah.
Now, two things. First, what would make that exempt? And second, I think that it's also important to note that, or to say to people if they might be worried and saying, I'm not going to contact anybody in Canada from now on, kind of, how do we ease that mindset? Or that?
It's tough. The best way to do that is to familiarize yourself with CASL and its exemptions, okay? So that's the first step, right? Yes, there are various exemptions, in addition to the implied consent we talked about, that you may be able to rely on, but they are very specific, and therefore you should know about CASL and B, and I'm not saying this to necessarily promote myself right now, but I'm saying talk to someone and get advice on those particular. But and especially in that particular situation, if this person has never been on your radar before, if they've never given you consent, if you've never had a relationship with them, this is purely either a networking or marketing reach out, which that's what we do these days. Most marketing is done online, is done through emails. Given with the exception of small, very specific situations, it's very likely that you won't be able to send that person an email without violating the Act. And so again, talk to someone who can give you advice on that, or simply pick up the phone. I would say pick up the phone. Yeah, because and ask for their consent.
Real, face-to-face or voice-to-voice communications again.
Yeah. Guess what? Voice-to-voice communications, luckily, are exempt under the Act. Yeah.
That's awesome. And I would also say for those, because I don't want to, the point of this podcast is to help organizations and professionals eliminate this, mitigate this particular risk. And it's a big risk, and I'm all about, crisis prevention, best form of crisis management. However, I'd like to say that if your intentions are legit, and if they're real, if they're legit, then I also wouldn't be too scared. I mean, unless the person you're sending to is having a bad day or is just a total, ass. You get those. That's always a risk, I suppose. But I would say, just like anything else, if it's legit, if your intentions are legit, then I wouldn't be too scared.
Well, yes and no. I mean, you're right. I agree with you. If this person would be interested in your services, they may not complain, and that's the first step. But you also have to keep in mind, and this is not at all an attempt to scare. In fact, I think they're very. I mean, what I do is I advise clients about how to deal with these kind of situations. But those are the one-offs, right? What matters is if you are a business or an organization, something that other than a one-person situation, what I recommend, and I really think is important, is to have in place compliance policy. If you're an organization, you already probably have various compliance policies in place, depending on what business you're in, what services you provide. But you should also have a CASL compliance policy, similar to a privacy policy, for example. And that policy would, if it's properly prepared and implemented, will probably avoid the kind of situation where you're reaching out to someone and in a manner that violates CASL, or in a matter, or even if you violate CASL, it would be more of a one-off situation as opposed to a regular thing. As you say, that's probably not going to lead to consequences. If it's a one-off thing, the likelihood of having a complaint is smaller. So really having that compliance policy in place reduces the risk. I mean, this is all about risk management, right? So it reduces the risk of that situation happening. And if it does happen, and it happens because you made a mistake, or your employee made a mistake, your staff member sent an email instead of calling, or your staff member didn't realize this person had opted out. Because the other thing you need to know is, under CASL, in addition to opt-in, you also have to have an opt-out option. So if a person had opted in, like in the example that you gave earlier about yourself, they've opted in to get a newsletter, and then later on they change their mind. If they opt out and you continue sending emails like you did, you are more likely than not.
Not like I did, like happened to me.
Exactly. You're more likely than not to have that person complain, because that is the person that made that a conscious decision to opt out, right? So now they're going to be saying, well, this is annoying. I'm going to go to the website and I'm going to complain. So, these are the kind of things you need to do as part of your compliance policy, which is basically figuring out a manner in which you keep track of consents, you keep track of opt-out, and you integrate that into your communication system. And that will reduce the risk. And also, if there's a complaint, you can then, one of the defenses you may raise before the regulator, which is the CRTC in Canada, the Canada Radio and Communication Commission. So if you have a compliance policy, you can come up and say, okay, this is a one-off. This won't happen again. As you can see, we've done our due diligence. We've prepared, and that, if it's properly done, if you have a proper policy in place, will give you an advantage and a defense, which is the due diligence defense, a way of avoiding being found liable. So, those are basically the best ways to deal with this with CASL, is really to think about it, educate yourself, and then implement policies to ensure you comply.
Awesome. So let's talk about, and actually I'm so glad that you brought up the compliance policy, because I wanted to talk about that. And there's many different, not many, but there's a lot of different angles even in just what you just said that need to be within that policy. From if if you're, reported or you somehow violated the CASL, or if you are as well the recipient. Correct? As an organization, you should have some form of policy to educate your team and on how to minimize their spam intake.
Oh, absolutely. I mean, it affects your organization. If you're, crowding your servers, I mean, you want to avoid that as well. I think it goes both ways. And once you educate the team, they will know. They'll have a better understanding.
So should organizations who want to develop a CASL compliance policy, should they hire a Canadian attorney for this, or do attorneys around the world who are policy creators and that, should they be able to do this as well?
Well, my recommendation would always be talk to a Canadian lawyer.
Because it's their home.
Yeah, and I mean, again, I'm a Canadian lawyer, but this is not necessarily my way of promoting. This is myself. I'm just, I've had situations where I've been consulted by particularly U.S. companies where they were getting advice from their in-house or their local U.S. lawyer about CASL, and unfortunately that advice was wrong because U.S. counsel are familiar with U.S. anti-spam laws, and there's almost there's a misperception, but also a feeling by U.S. counsel that, it's probably the same as we have here. So no, and it's certainly not the case. So it's really important to get advice from the people who are actually
like
involved.
with everything. I mean, and I talk about this often with even just in-house counsel who will bring me in for some form of training or workshop, and they'll say things like, "Oh my God, why didn't we think about that?" And it's the same answer. Your job is your job, and you have a lot on your plate, and you can't know everything, and you can't think of everything. And this is why it's so important to have a big network of whether it's subcontractors or partners or just consultants that you can go to, because they do specialize in these certain areas.
Certainly. And there's also the thing about CASL again is people assume it's all about spam or electronic messages, but in fact there are other aspects to it, which involve electronic communications and electronic activities. And again, in-house counsel will not necessarily, most likely not be aware of it or not be familiar enough with it. Moreover, it is so complex that poor in-house counsel will sit there, and I've had that experience, in-house counsel sitting there trying to figure it out and getting it wrong. And frankly, lawyers even in that are been practicing in the CASL field right now in the past 6 months, don't forget this is relatively new, don't necessarily agree on every aspect of it because it hasn't been tested, hasn't gone to court. No court has yet to consider it.
That was one of my questions, if there's precedents that.
Well, no, there isn't. It's so new, right? So there's no precedents to rely on, and not to mention the fact that it's a web of regulations. There's a legislation, but there are always different. There's also various regulations. There's practice directions by there's three different regulators. Okay, so and everybody has a different approach, and so I constantly come into a situation where I talk to a client says, "Oh my God, we spoke to a different lawyer who told us something completely different." And I will say, "Well, you know what? I'm not necessarily going to say they are wrong. I'm going to say I disagree with them because this is how I interpret the regulation, that particular regulation, because we just don't have a clear indication as to how it will be applied in court. And when it will, we will know better. But so even it's one thing to ask in-house counsel that has so much on his or her plate, but even external counsel, it's recommended that you seek out someone who has actually been involved in this particular area and has done work in it, because it is new and it is different.
Yeah, and you don't want to be the guinea pig.
Yeah, no, absolutely not. And there's going to be many, because as far as I can hear, and I hear from the CRTC, since July they've received over hundreds of thousands of complaints, certainly over 100,000 so far. I don't know exactly the number of complaints for under CASL. So, I mean, there's going to be someone that they're going to take, and they're going to, and you don't want to be that one, that particular organization.
So what are the consequences for violating CASL?
Well, they're serious.
Yes.
I think
They're
that's
scary.
why. Yeah,
They're
they're
scary,
scary.
which is why this is so important to understand as a risk and how to prevent,
Yeah.
this from happening to your
Yeah.
organization, no matter where you are in the world. I can't repeat that enough.
Yeah, no, absolutely. I think that's why, back in July, the media was really storming around this because when they caught wind to what can happen if you violate it, it's concerning. It's scary, like you say. So here's how it goes. So the first thing that there are many consequences that can happen for someone who violates CASL. The first and most obvious one are fines, or what the regulator calls. They say it's not fines. I don't know what they mean by that, but they call it administrative monetary penalties. How is that different from a fine? I don't know. Anyway, no matter what, they can impose up to $1 million on an individual per violation. That means one email, okay? Up to $1 million in fines or administrative monetary penalties, and up to $10 million on organization. So that's an up to. Obviously, it could be anywhere from 1 to 10 million. And we don't know thus far how they're going to apply, because the CRTC, which is the regulator, has said that they are not necessarily going to apply a sliding scale approach. In other words, they're not going to say, well, your first violation $100, next violation 1,000, etc., and it's right. They said they're going to apply their discretion on a case by case basis to decide how much they're going to seek or how much they're going to impose. So it could be anywhere from 1 to 10 million, right? And 1 million or 10 million, those numbers can put any organization of business out of business, right? That's it. It can bankrupt someone. So those are very concerning, and that's the main concern I think everybody has right now. Then, of course, there are so many other consequences that can happen in addition to those. In addition. So first of all, the one thing that CASL does and the regulator has said is that they want to make sure that there is buy-in by the people who run organizations and businesses. In other words, they want to make sure that you take the heads of those organizations take this legislation seriously. And so the legislation imposes personal liability on directors and officers of corporations, which is serious. I mean, you're sitting as a director of a corporation. It could be a nonprofit organization, then you may even be doing it voluntarily, and yet you are exposing yourself to this type of liability. So that's serious, and I think that's something that the directors and officers of corporations and organizations need to be aware of. So that's again, that's one of the other serious consequences. In addition to that, not yet, but coming up in July 1st, 2017, the Act will create the option of civil actions, which basically means that anyone, such as yourself, who is on a receiving end of a violation, such as an email, can sue. So you can sue in court for damages. And think of one email going up to 1,000 people, and now we have a class action involving 1,000 people, and we are talking, class action for multi-million dollars. So, because of one person clicking send that email going out to 1,000 people. So, and I got to tell you, I'm not a plaintiff side lawyer, and I don't practice plaintiff side class actions. But I am sure that there are plaintiff side class action lawyers out there just waiting and biding their time for July 1st, 2017. And they will, and once that comes, we will most likely see those class actions all over Canada. So that's something to keep in mind. Certainly, there's a different approach that a court will take in a civil action than it will, for example, in a regulatory matter. So, and that's important. Yeah.
And how easy is it to report a violation of CASL?
Can't be easier than going to the website. The website is fightspam.gc.ca. It's a website that is managed by the CRTC, by the regulator, and just fill out a complaint. That's it. So there's no lineups. You don't have to go to a government office. You don't have to do anything. You just go and you do it. And which is what's one of the reasons this act is concerning, because it's so available to anyone to just go on their phone, on their computer, and just file a complaint. And that starts the process. And as you can see, we have the CRTC is now dealing with hundreds of thousands of complaints that they have to sift through. And I'm sure they have a lot of work, and I'm sure they're very busy right now.
Oh yeah.
So yeah, no, they made it easy. And I heard, I don't know if this is, I can't say if this is true, but I actually heard story a while back. Someone told me that at the time when the CRTC was planning this and they wanted to put up a website to do this, they had put out a bid to the private sector to say, does anyone want to run this website? And they got 0 bids. No one wanted to deal with this headache. So now the CRTC is handling it on its own. And you know, whether, again, that means that, you know, considering government resources, I don't know how they're managing, but it's going to. So if you're on this receiving, if you filed a complaint, it might not be dealt with for a while. That would be my assumption. I just don't know. And you could be responding to a complaint a while after it was made, which also makes it a little difficult for you to deal with, right?
Absolutely. So when I report, you know, the 1 or 2 times that I've reported somebody, I forwarded the violating email to an email at fightspam.gc.ca. Is that a possibility too, or did I do that wrong?
I'm not sure. That might be option, right? I mean, but I know that if you go to their website, you can certainly fill out a form of them.
Okay.
Again, I think the bottom line is that it's easy, right? It's so easy. Like, anyone can do it, and that creates a problem for if you are on the receiving end of that complaint, right? It just makes it anyone, you know, any person able to do that. On the other hand, if you want to file a complaint, that makes it easier for you, and it's a good thing. So
yeah, it just makes their life more complicated. But it needs to be easy if they wanted this to be taken to actually work. So I've got a question, because I'm not an attorney. So how is Canada? Now you keep saying the do you say
CRTC?
TC. Okay, that's what I couldn't hear if it was 2C. Yeah. Anyways, okay.
Yeah. So CRTC is the I can never say it properly. Canadian Radio and Telecommunications Commission, which, as you may be aware of, because you are in Canada, they are traditionally dealt with radio and telecommunications. So cable companies, you know, they have traditionally regulated the big internet service providers and the cable companies. So this is a completely outside of their what they are used to dealing with, right?
Okay, so yeah, but okay. So how are they able to hold organizations and individuals in other countries around the world accountable for violating this legislation?
That's a good question. Okay, so it's not as simple as that. I think the law says that they are liable. Okay, the law says that anyone who communicates with someone sends a commercial electronic message to someone in Canada will be liable in the same manner as whether or not they sent it from Canada or from outside of Canada. And by the way, it doesn't matter where their servers are. You know, a lot of people think that if their servers are outside of Canada, they're not liable. That's not the case. Doesn't matter. But from an enforcement perspective, my thoughts are is that it's not as simple as that. So it would depend on the type of involvement or the type of synchronization that there is between the CRTC and the regulators in the country where this organization is. So, for example, if the organization or business is in the U.S., there's a lot of cooperation between the U.S. Regulators and CRTC, or at least that's what the CRTC is saying. Okay, so they said that they are cooperating with their counterparts in the world, and the U.S. being a major counterpart. So they say they're working with the local regulators, but I think if you are in Eastern Europe somewhere, it would be different than whether or not you are in the U.S., for example. So it really has to do with cooperation, and of course, if you are carrying on business somehow in Canada, they certainly have an ability to go after your income here or your assets here. That's for sure, right?
Mm-hmm. Okay. Oh, it's interesting. So that was always a question on my mind, which totally makes sense. But sometimes it's difficult to think. Even just I'm on the other side of the ocean, so this can't apply to me, or good luck coming after me. But they've put measures in place that you are liable.
Well, you are liable, and again, the question is whether or not they can actually enforce it, right? Can they impose fines? How do they make you pay those fines? So they can impose those fines, but how do they go after your money if you don't pay it? So it would depend on whether or not they have local cooperation with local authorities, or alternatively, if you are doing something that involves getting money from Canada in any way, shape, or form, they certainly can go after that. And that happens in any kind of situation legally when it comes to the internet, right? There's always that issue of, how do we actually enforce it? How do we go after you locally? How do we go after your assets?
And once precedent starts being set, then this will become clearer for us.
Exactly. I mean, we don't know how they're doing it. And again, it's what they say, right? I can only go by what they're saying, and they are saying, oh yeah, we have strong cooperation and strong, not only just in terms of enforcement, but also in terms of intel, right? They're gathering intel with their local regulators. That's what they say.
Okay.
And they need that. They need that information if they're going to find out who's behind certain. I mean, often, a lot of these emails come from people you really can't track very easily, right? So for tracking purposes, they're saying that they're cooperating with the local authorities.
Okay. So at the start of this conversation, you said that CASL is tough on spam and tough on hackers. So
yes.
That piqued my interest, because we've talked about the spam, or just the commercial electronic messages, and what that looks like and what's being defined as such. But how does this apply to hackers?
Okay, so in addition to the commercial electronic messages sections of CASL, there is another section to CASL that deals specifically with what is referred to as computer programs. And this actually is so unique that there is no, as far as I know, no similar or legislation or regulation or laws in the world that are like these. And what they have done is that they're really trying to, again, be tough on hackers. We're going to go after hackers, but instead of actually focusing on the hackers, they have decided specifically, or like malware or spyware, they are going after all computer programs, and those particular those sections of CASL say that if you are causing someone to install a computer program, and that means any form of code. It could be an app, it could be a software, it could be anything whatsoever, games, whatever it is, and that also includes upgrades, updates, etc. Any type of computer code, if it's being installed on someone's computer in Canada, and again, a computer can be a device, phone. Right? It could be anything.
So
anything
really,
that has
remote electronic device.
And frankly, any device. I mean, if we think about these days they talk about the Internet of Things, right? There's internet in everything. It could be anything. It could be a car. Anything that has a computer in it.
The upcoming fridges.
Yeah. No, exactly. That's exactly it. It could be a doll, right? A talking doll. Any type of at least the way it's drafted, it says that any form of code being installed on a device in Canada is subject to this regulation, and it says that you cannot actually install it without seeking specific express consent from the person who owns that computer. And there are also specific details on what you have to include in that consent. And I'm not going to get into it. It's they're very detailed. But the point is that there's computer code in everything, right? Mm-hmm. Everything. And if you are selling any form of product, if you distribute any type of anything that has computer code, whether you are a software developer, you're a marketer, a distributor, whatever it is, you have to make sure that you're now going to be complying with these requirements if you are going to be selling or distributing in Canada. And what I'm saying, I said, are you going to be? Because these sections haven't yet come into force. They're coming into force soon. They're going to start in January 15, 2015. So they're coming up. After that, we're talking, the same type of fines in the millions of dollars if you violate this. And you can see how this would apply to hackers, sure, because hackers install bad computer programs.
Spyware and stuff. Absolutely. Yeah. But what about, I'm thinking it doesn't really apply, or does it? Is it to hacks like what happened to Target, for example?
Oh, yeah. It would apply to all of that.
So where does that come in? Because that was an external hack.
Yeah. So here's the interesting part. CASL doesn't impose liability on the person who was hacked, like the organization that was hacked, because they see them as the victims, right? Mm-hmm. So if you are Target or Home Depot, for example, and you're being hacked, CASL doesn't say you will be suffering some kind of regulatory fines, etc. It's only the hackers or the people who have actually done the work. And that's important. You want to go after these people, right? And we haven't had that legislation before, so now we do. That's fine. That being said, it doesn't mean if your organization and your security is flawed and someone is able to hack into your system, that doesn't mean you're not going to be subject to some form of legal liability in Canada. That's a whole different issue.
CASL.
Yeah, but not under CASL, exactly. A whole different issue. That's civil liability, and there's also various other acts, legislation that's working its way through. So that's different. But at least if your target, CASL is not the issue. I think if your target, though, if you have an app, for example, which you probably do, then you have to make sure that when you have someone install the app on their phone or upgrade that app, etc., that you comply with CASL's requirements regarding consent. And that's already, most organizations already have that. They have that request to consent, right? I mean, you're asking someone to consent to install an app on your phone, but that request for consent may actually not comply with CASL's very technical requirements of what should be in a consent. It's very strange.
Which is awesome, because right now apps there's a big issue there.
Right. Well, here's another thing about those apps is that they're all over the map. As you say, there's a big issue. They're all over the map, and you don't know what you're getting. You don't know what you're getting on a computer. So that's important. In addition to that, what CASL does, and this is a good part of it, I like that, is that it says that if that particular computer program or app performs a certain function, and it lists those type of functions, that specific function has to be explained to the person who owns the computer plainly and simply. In other words, don't use techie. Yeah, exactly. Don't use techie language. Explain what it's doing and ask for that particular consent in addition. So, for example, and this is how they're trying to go after hackers, if that particular computer program causes the device to communicate with another device, which is very common these days. Again, and in innocuous stuff, not necessarily in bad, in malware, spyware, but this is actually, a lot of computer programs do that. If it causes it to communicate with another device, you have to tell the person who's installing it that that's what it does, and you have to explain it, and you have to seek their consent for that. And if you don't, you're going to be violating CASL. So again, these are very specific details that if you are in that business, you have some form of computer program that you are dealing with, you need to make sure that you comply as of January. And it's coming up, right? So it's stuff you need to deal with. You got to talk to your IT people, and you have to make sure it's in there.
Very good. And what about cookies? I'm interested. So
yeah, everybody worries about cookies because everybody has cookies. And frankly, I'm not a big fan of cookies. I can't stand the fact that I go to a website and then next thing you know, they know exactly what I'm interested in. I get 10 other. I mean, it's just it bothers me personally. But cookies has been exempted from seeking that express consent, but that being said, it's not fully exempted. And cookies and other types of programs. There's specific programs that have been exempted, operating systems, Java. So more of the common programs, and cookies, of course, is one of them.
Operating systems, that's interesting.
Yeah, well, I mean, that's
your system.
Yeah, exactly. I mean, if you have to seek consent every time you upgrade the operating system, that's going to be a problem. So those are. But then again, the exemption is not a complete exemption. There's language in the act that says only if it's reasonable to have expected that person to consent to it. So it's kind of strange, and we don't know yet how it's going to be implemented by the regulators or by the courts. We don't know. It's kind of strange. Yeah, so I'm not going to say it's a full exemption to cookies. I'm saying you got to be careful with cookies too, because there's almost there's a caveat there, and we don't know how it's going to work. And you look at my understanding. I'm not a UK lawyer, but my understanding is that. I could be wrong. I think in the UK there's laws regarding cookies, and I think you got to seek consent for cookies. So
the UK is so much more advanced than North America with privacy and issues around it.
Right, and I think that's important. And the other thing you got to be aware of is that you just mentioned privacy, and that reminded me is it ties into privacy, right? So the CASL ties into the PIPEDA, which is the federal privacy legislation in Canada, and it amends it to make sure that to prohibit the collection or etc. the collection of personal information online without consent. So you got to be careful of that about that as well, and that's part of CASL in a way.
Okay.
One of those particular that personal information, CASL says, includes email addresses. So if you're collecting someone's email address online without their knowledge, you are violating CASL. And that's, a lot of organizations will have email harvesting, right? They'll have those types of systems or those types of programs. And that is prohibited under CASL without first advising the person that you're doing that and seeking their consent, which frankly I like that.
Yeah, but what if they then turn around and don't send an email to that email address? What if they just, there must be caveats there where it can go undetected and we're not completely safe from.
Well, no, obviously, if you don't know that someone is collecting your email address, then it's most likely you're not going to complain. But that being said, if they are doing it, they are violating CASL, right? There's no question about it.
So, question, if they do that, they don't send, but they're doing that for the purpose to sell it to third party. If that third party then spams, can that, this is a big, I guess, a loaded question. And so then that third party violates CASL by emailing the recipient, and the recipient reports them.
Yeah, no, both parties.
Both parties.
Yeah.
Wow.
Both parties will be liable for violating CASL.
Guarantees.
Yeah, well, I agree with that. Like, I think, if it's really spam, then yes, that's good, right? Obviously, that's good. The problem is that the buying and selling of email addresses is so common these days in the marketplace.
But it's a problem.
Which is a problem. I agree. I absolutely agree, especially if you're concerned with privacy. I absolutely agree. And that's what CASL is meant to do. It's got to stop this. And but then again, I often get questions from clients, from organizations that said, we bought this list. What should we do with it? I'm like, well, throw it out. Like, get rid of it, right? Like,
chalk it up as a bad mistake and a waste of money.
Yeah, no, absolutely. Don't buy those emails. Or if you're going to buy the emails, make sure that the person who's selling you those emails has followed the right procedures. In other words, they have sought consent from the people whose emails those belong to A, gather their emails, and B, to communicate with them, and have you communicate with them, which is also very important. Like, they have, someone you can't, if you're asking for consent, you've got to ask for consent on behalf of everybody who will later communicate. So that's what you got to do. So it is not necessarily wrong to buy them. It's just make sure that the people whose email they'll belong to actually agree to that, right?
Absolutely. So speaking of to-dos, what are the things that organizations, no matter where they are in the world right now listening, can actually write down and say, okay, this is on our to-do list. This is what we have to do to make sure that we do not violate CASL.
Well, there's quite a few things. The first thing you have to do, and I always recommend, is sit down. Before that, step back. Familiarize yourself with CASL and its requirements. Educate yourself, okay? Call a lawyer who knows about it, or even there's lots of information out there about it right now, and lots of law firms have it on their websites. Certainly, get to know it, okay? And then after you get to know it, you got to do what I always say is you got to do an audit. You got to sit down, review your modes of communication, who you communicate with, where you got those emails, where you got the information from, and figure out whether or not you can, how you can tackle this, because you will see as when you do your audit suddenly that there's a group of contacts that you can continue communicating with, and there's always a group that are sort of the gray area where you're not sure whether you have consent. And that's where you then sit down and figure out what to do about those people. How do you get consent from them? In what form? And just a little caveat, that's an interesting thing. Speaking of consents, something that CASL does, and I forgot to mention that earlier, it says that as of July 1st, 2014, you cannot actually send an email to someone seeking their consent. You can't do that.
What? Like an opt-in, a double opt-in? Like,
You cannot do that because the Act says an email sent seeking consent under CASL is a commercial electronic message and is therefore prohibited. That's what the Act says.
Hold on a second. What if they, like, for example, I'm thinking my newsletter. My newsletter has a double opt-in. So you register, you choose to provide me with your information, right, and then I send you an email saying, are you sure?
Yeah, no, that's fine because they've already opted in. The issue is if someone hasn't opted in, right?
Okay.
You haven't had an opt-in.
Like those lovely people that you meet in a networking event and then who subscribe you automatically to their freaking newsletter.
Right. Well, that's a way of not getting consent, right? That's what. But in any event, let's assume you've gone through your list and you realize you have all these people that you've never gotten consent from, but you're still sending them emails. So now it's time to change, right? You got to go to get consent. Well, you can't do it by sending them a mass email saying, "Can you give me consent?" You can't do it. The Act says by doing that you are violating CASL. So you have to figure out other ways to do it.
Bottom line, delete it. Delete
it or call them or send them snail mail, printed mail, faxes, whatever it is. Get another way, figure out ways to engage them. You shouldn't be giving up. I never say give up. Marketing is important. Just there are ways to get around it, but just do it in accordance with CASL. So that's another way to do it. And then finally, when we're going back to the list, you got to sit down and prepare a compliance policy. That's very important.
Okay, so make sure. And is there anything else that and I didn't mean to give up, but I mean it is so much better to, if you think that maybe something's in the gray zone and it can be followed with millions of dollars worth of violation fines or however the legislation worded that, then you have to just ask yourself, is it worth it?
Yeah, it's a risk management decision. And really, and that's something I say also to clients, I said, don't leave that risk management decision to your IT guy or to your communications employee or your marketing person. Make sure it gets decided by the people who should make the decisions, like the top people. Because don't forget, there is directors and officers liability. You want to make sure that if you decide, we're going to communicate anyway because we think it's a low risk and it's important, from a risk benefit analysis, we're going to continue communicating. Have that decision made by an officer, someone at the top. Okay, because you really don't want someone.
No, it's an important decision. It's an executive decision.
Exactly. It's got to come from the top, and you'd be surprised. But I have a lot of organizations come and say, "They left it to the executive assistant." I mean, no, don't leave it to the secretary to make that decision. Really, make sure that there's input from everybody who needs to make those input, and don't necessarily give up, but make it a risk management decision. That's the bottom line.
Excellent. Maanit, this is so interesting. I knew, and not just interesting, but so important. And like I'm seeing, even personally, it's so new. And organizations around the world, they're not, unless you're in Canada or close to Canada, like in the US, likelihood you might not even know that this legislation exists and you might be violating it right now. So thank you so much for having this conversation with me. For those who want to learn more, where can they find you?
Well, they can find me on my website. And it's actually, now, if you've listened to CASL, you will find it relatively easy to find my website. My website is caslaw.ca. So it's www.cas as in Sam, law.ca. So caslaw.ca. Or you can email me at mzemel@caslaw.ca, caslaw.ca. I promise I won't complain.
I was just going to say that.
I was going to say, I'm not going to complain about you.
I will never
even if it's don't send me spam, real spam. But if you hear this podcast and you want to get more information, certainly I open it up. You can certainly contact me. So
awesome. Thank you so much for having this conversation with me.
Thank you very much for having me.
Take care.
Take care, Melissa. Bye-bye.
Thank you so much for tuning in and listening to this week's episode of the Crisis Intelligence Podcast. I release a new episode every Sunday, so if you haven't already done so, be sure to subscribe to the Crisis Intelligence Podcast over on the Crisis Intelligence blog at agnesday.com/blog, or on iTunes or on Stitcher. And while you're at it, head on over to iTunes and Stitcher, and would really appreciate it if you left us a review and your feedback. You can also follow me on Twitter at Melissa_Agnes. And if you'd like to reach out to me to ask me a follow-up question from this week or a past podcast, or if you'd like to discuss the possibility of having me come and speak at an upcoming event, then you could email me directly at magnes@agnesday.com. Thanks so much for tuning in this week, and I look forward to talking even more crisis intelligence with you next Sunday.